Good evening, guys. Welcome to Football Council. Tonight, we're going to continue to talk about the international transfer of minors regulations, particularly exceptions number 3, 4, and 5. And prior to that, I want to point out that most of the information provided here was taken from the commentaries on the regulations on the status and transfer of players. So if you want to further expand on your studies, that's the document to go to. So that being said, and for the purposes of this presentation, we again need to remind ourselves what a minor is pursuant to Article Definition 11 of the regulations on the status and transfer of players. In said document, a minor is defined as a player who has not yet reached the age of 18. So again, let's recall that this definition does not take into account any national applicable law that may state a different age for adulthood. So for the purposes of the RSTP, again, a minor is a player who has not yet reached the age of 18. Pursuant to Article 19 of the Protection of Minors, one, international transfer of players are only permitted if the player is over the age of 18. In other words, the international transfer of minors is prohibited as a general rule pursuant to RSTP regulations. So let's start with exception number 3, the cross-border transfers. Article 19.2c states in this exception is as follows. The player lives no further than 50 kilometers from a national border, and the club with which the player wishes to be registered in the neighboring association is also within 50 kilometers of that border. The maximum distance between the player's domicile and the club's headquarters shall be 100 kilometers. In such cases, the player must continue to live at home, and the two associations concerned must give their explicit consent. So, in further detail, this exception covers the situation in which a minor player who lives close to an international border wants to play football on one side of the border while living on the other side of it. For this exception to be applicable, the minor player must continue to live at home. Obviously, stipulating that the player must live at home reduces, if not eliminates, any risk of their being uprooted because of the transfer, because of course, the minor remains with their parents in their family environment. It's important also to point out that both member associations involved in the transfer must give their explicit consent to the move prior to an application being made. Furthermore, the exception includes several requirements as to the distances associated with the transfer. Firstly, the player must not live more than 50 kilometers from the natural border concerned, and the club with which the player wishes to register must not be located more than 50 kilometers from that border. This is measured the principle is known as the crows flies. So it's basically it's measured in a linear way. So you take the domicile of the player, and you draw a line to the nearest point of the international border, and that has to be within 50 kilometers. Same with the headquarters of the club. At the same time, the distance between the player's home and the club headquarters may not exceed 100 kilometers, but different from the previous distance measure. This is measured in terms of the route actually traveled by the player. So different parameters to measure each one of the criteria. All these requirements must be satisfied for the transfer to be approved. So for the purposes of this exception, the player's parents will not be deemed to be moving internationally provided the player continues to live with one of their parents and the parent concerned holds legal custody of the minor. The same applies where a player is living with a third party, namely a legal guardian, who has been awarded parental authority by the state either because both the player's parents have passed away or because parental authority has been removed from the player's parents. So now let's dive into exception number 5, would be the humanitarian exception. Since this is such a detailed and long exception, we're just gonna go straight to explaining this exception. So for this exception to apply, the minor player concerned must have migrated to another country with other parents on humanitarian grounds. It's important to point out that prior to the November 2022 reform, this was limited to minor players with the formal status of refugee or protected person in their country of origin. However, in practice, it has become clear that the exception did not sufficiently cater to the reality of thousands of unaccompanied, displaced, and vulnerable children moving internationally. that do not fall within the formal legal definition of refugee. In view of this, the regulations were broadened. So a minor player that has migrated to another country without their parents on humanitarian grounds will therefore qualify for the exception where they are at least temporarily permitted to reside in the country of arrival through issuance of a visa, for example, government decision or court order, or are recognized by the competent state authorities of the country of arrival has been vulnerable and requiring state protection, for example, to legislation or government decision. Also, the minor has flown or left the country as a result of their life or freedom being threatened on account of race, religion, nationality, belonging to a particular social group or political opinion, or secondly, any other circumstances where their survival is seriously threatened. So also, in order to avoid abuse, applications submitted by professional clubs to register a minor utilizing this exception will only be accepted where the player has been formally recognized by state authorities as a refugee or protected person. Applications submitted by purely amateur clubs may be accepted where the player has, in any scenario, formal recognition, is an asylum seeker, or is deemed to be a vulnerable person. Minors that are registered based on a formal recognition of their refugee or protected person status are not subject to any restrictions upon their subsequent transfers. On the flip side, minors that are registered on the basis of being an asylum seeker or vulnerable person may be transferred nationally, but are not permitted to register with a professional club until the age of 18. With regard to minors being vulnerable, recent decisions of the player status chamber were accepted, provided these criteria were met. Where a decision by a state court or a confirmation by the relevant authority underlines the minor vulnerability and or need for state protection. 2, the move of the minor is not linked to football in any way. And 3, provided that the club for which the minor wants to be registered has a purely amateur status again. So if a member association uses the transfer matching system to submit such an application, the former member association, in this case, of course, assuming the minor player was purely registered, will not have access to the information contained in this application. The reason for this is to reduce any risk or any security risk to the player or their family, because concealing these details reduces the likelihood of the authorities in the player's country of origin becoming aware of their whereabouts. It's basically for the safety of the player and its family members. So that would be that exception. Exception number 5, and lastly, would be the exchange students exception. So pursuant to Article 19(2)(e), in this scenario, the player is a student and moves without his parents to another country temporarily for academic reasons in order to undertake an exchange program. The duration of the player's registration for the new club until he turns 18 or until the end of the academic or school program cannot exceed 1 year. The player's new club may only be a purely amateur club without a professional team or without a legal, financial, or de facto link to a professional club. Very important, it has to be a purely amateur club. This exception was introduced into the regulations on March 1st, 2020, having codified existing unwritten exceptions found in the former Player Status Committee jurisprudence. So first, the minor player must really have moved abroad or accompanied by their parents for academic reasons. Secondly, given that playing football is a purely leisure activity for the player concerned, the player's proposed new club must be a purely amateur club as defined in the regulations. And lastly, the maximum duration of the minor's player's registration for the new club is limited and may not last longer than 1 year. So as per FIFA circular number 1709 of 13 February 2020, the minor player must be supervised throughout their academic program by host parents. These host parents must provide the player with accommodation. Moreover, both the minor player's parents and the host parents must consent to the players being registered with the new club. This is a very important requirement. So that would be the 5 exceptions contemplated in Article 19 pursuant to the general prohibition of the international transfer of minors. But of course, there are other topics that are very interesting and require our attention tonight. One of them would be the 5-year rule. So Besides the 5 exceptions listed on in Article 19, paragraph 2, there is one more set of circumstances under which a minor player can be registered for a club outside their country of origin. This is known as the 5-year rule. The rule is only applicable to the first time a player is registered. So the player, in this case scenario, the player has never been registered before. In this regard, it is worth remembering that if a period of 3 months elapses between a player's last appearance for the previous club in an official match and the player being re-registered, the player's registration as a footballer will be considered to have lapsed, and the new registration will be treated as a fair registration. This rule also states that a foreign minor player who has never previously been registered with a club and who has lived, namely being physically present, for at least the last 5 years in the country where the member association at which they wish to be registered is domiciled, should be treated as a national of that country, both from a sporting point of view and in relation to the provisions on the protection of minors. An uninterrupted presence of at least 5 years in any one country constitutes, of course, a significant period of a young player's life. Therefore, the rationale behind this exception or this rule. This period refers, of course, to the 5 years directly prior to the registration. So, in regards to the applications for first registration, and to prevent any attempt to circumvent the provisions on the protection of minors, it is essential that the rule, the exceptions, and all other principles of Article 19 must also apply to the first time a minor is registered as a player in a country where they are not a national. This fundamental principle has been confirmed by CAS in a number of awards. We have chosen a very famous one, which involved Football Club Barcelona versus FIFA, namely CAS Award 2014-A-3793 for those who want to study that award. So let's talk about the Player Status Chamber, previously Player Status Committee approval of the exceptions. So to improve monitoring and exert more control over the way the rules protecting minors were implemented and to ensure that the exceptions were being applied consistently and correctly, the Player Status Committee was created on October 1st, 2009. The creation of the Player Status Committee thus shifted responsibility for adjudicating such cases from the associations to FIFA. After that, and more recently, on October 1st, 2021, the Player Status Committee was abolished and its competence absorbed into the newly constituted Player Status Chamber of the Football Tribunal. The Player Status Chamber, therefore, has the authority to assess and decide on all proposed international transfer of minor players and fair registration of foreign minor players. So if a member association wishes to register a minor player for one of its affiliated club, it must obtain the approval of the Player Status Chamber to do so first. To obtain this approval, it must submit the relevant application at the request of its member club. Approval must be received prior to any request for the player's international transfer certificate and or the first registration of the foreign minor player involved. This is very important. To ensure that the principle of due process and in particular the right to be heard are respected, the Player Status Chamber grants the member association with which the player was previously registered, if there is one, the opportunity to submit his position on the proposed transfer. As explained, cases in which a minor player moves for humanitarian reasons are an exception to this general rule. Okay, this is also very important. An international transfer certificate is not required to register a player under the age of 10 because it has a particular regime. So if a member association intends to register a player below that age at the request of one of its clubs, the member association will not be required to apply to the Player Status Chamber for authorization. Nevertheless, the club and member association concerned will be under even greater obligation to ensure that the player does qualify for international transfer pursuant to the regulations. This must be verified by the member association before the player is registered. So let's talk about the limited minor exception. The grant of a limited minor exception relieves the member association of the obligation to make a formal application for approval to the TMS to the Player Status Chamber. Limited minor exceptions will only ever apply to minor amateur players registering with purely amateur clubs as defined in the regulations. All other applications involving minor players would still need to be submitted to the player status chamber. In accordance with Article 19b, paragraph 6, limited minor exceptions do not apply to minor players joining an academy if that academy has a link to any professional club. That's important. It has to be a purely amateur club in order for this limited minor exception to be granted to the member association in question. So provided the relevant conditions are met, an association may request a limited minor exception by lodging a written request to the player status chamber via TMS. If granted, the limited minor exception is normally valid for a period of 2 years. When it expires, the member association is free to request an extension, of course. If a limited minor extension is granted, it will be the members association responsibility to verify and ensure prior to any request for an ITC for a minor player and or its first registration of a foreign minor player that the player concerned does indeed qualify for one of the exceptions or falls under the 5-year rule. So the fact that they grant the limited minor exemption still the member association is under the obligation to comply with Article 19 and the exceptions provided therein. So lastly, let's talk about the sanctions regime. The FIFA Disciplinary Committee will impose sanctions for any violations of the provisions on the protection of minors. Thus far, sanctions have only ever been imposed on the proposed new club and its member association. Since the applicable rules and regulatory provisions do not impose any obligation on minor players, they cannot be subject to any sanction for violating the provisions on the protection of minors. In regards to the burden of proof, in establishing a disciplinary infringement, it lies with FIFA. In pertaining the standard of proof and in accordance with Article 39, paragraph 3 of the FIFA Disciplinary Code, the standard is to the comfortable satisfaction of the competent judicial body. This is backed up by a number of case awards. We have chosen a few. Case award 2016-A-4805, Club Atlético Madrid, Sociedad Anónima Deportiva versus FIFA, and case award 2019-A-6301, Chelsea Football Club versus FIFA. Let's just remind ourselves that this standard of proof, the comfortable satisfaction of the competent judicial body, is a higher standard of proof than those standards required for civil proceedings, but it's definitely a lower standard than that required in criminal proceedings, which is that beyond a reasonable doubt. So finally, any disciplinary sanction imposed for failure to comply with the provisions on the protection of minors must abide by the principles of proportionality and adequacy. In this regard, CASA has found that if a club tried to prepare the situation by retrospectively seeking approval from the player status chamber for international transfers and or for the first registration of foreign minor players, such attempt should be considered as an important mitigating factor. This is pursuant to CASA Award 2016-A-4805, pretty cited, Club Atlético Madrid, Sociedad Anónima Deportiva versus FIFA. That same CAS panel also emphasized that breaches of the substantive provisions of Article 19 were deemed to be of the utmost gravity and should therefore attract particularly severe sanctions. So that would be our session for tonight, and with that we will end with the international transfer of minors regulations. Of course, we remain at your disposal to further expand on this or any other related topic. And we take the opportunity to thank you and also to invite you to next week's session that we will be announcing through our social media accounts. So until then, guys, please be safe. Bye-bye.